Right, now we have looked at the court system. We have also looked at the tribunal system. Now we're going to be looking at the third system. Arbitration. Okay, arbitration is an alternative to a court and a judge. Parties normally agree to go to arbitration by including within a contract an arbitration clause. Full stop. Now we are going to be doing contract law later on, much later on, and when we get to that point you will see that contract will have various terms, various conditions, various restrictions, and so on and so forth. And one of the clauses within that contract could be that if there is a dispute in relation to the terms of employment or the daily responsibilities that they are responsible for undertaking as a consequence of the contract, is to go to arbitration. So in their normal way of business, there is a clause that states if there is a dispute in carrying out your work and so on and so forth, then to resolve it means going to arbitration. So this system of alternative dispute resolution, ADR, is a little bit exclusive because the parties are already bound by a contract or by a term in a contract that if any disputes arise, then they go to arbitration. So it automatically cuts down the prospect of the parties going to court to sue. It also cuts down the possibility of going to a tribunal. They are generally restricted by this arbitration clause within a contract which says any disputes, they need to go to arbitration. Okay. So an example, let's just give you an example of a clause, an arbitration clause. If you want to put in quotes or example of arbitration clause, okay, the example reads, if any dispute arises between the parties they agree that now they can choose which arbitration association they go to resolve this dispute. Now I'm just going to give a random name. So if any dispute arises between the parties, they agree that the Canadian Arbitration Association gives the parties a fair opportunity to present their case and respond to the case of the other side. Full stop. The arbitration shall be held in, let's say, Calgary. The arbitration shall be held in Calgary and shall proceed in accordance with the provisions of the Alberta Arbitration Act. Full stop. So that is really just an example. So if somebody walks into the office and they are aggrieved about some dispute relating to the terms of their employment. Maybe the terms of the employment was that they work for X number of days before getting paid holiday and so on and so forth, and suddenly they are now in a desperate situation. They wish to go on leave because maybe there's illness in the family, and you know, all these disputes can get out of proportion. And so if they then decide that they want to take their employer to court, first of all you need to know what is said in the contract. Of course, they may have no understanding of the contract they signed originally, so you would need to see a copy of the contract. If within that contract there is a clause that says disputes must be resolved by arbitration, then that's where you have to go. You have no choice. If there isn't such a clause in a contract, then where else would you want them to go? To a court, which is more expensive, or to a tribunal? So these are the reasons why you actually need to revise, know which legal system you would need to use for whatever. So you know what the court system does, you know what the tribunal system does, and now you know when it would be necessary to go to arbitration. Okay, of course, you don't have to have such a detailed arbitration clause. You could just have an arbitration clause that says something like any future dispute arising out of the contract will be settled by arbitration. So the parties can decide which arbitration they go to, and so on and so forth. So it can be a little bit vague, but it will state that it should be settled by arbitration, either in a formal way or in an informal way, as I've just said. Okay, new paragraph. Both parties will agree to its inclusion and once agreed, the clause becomes a condition of the contract. Okie dokie. Full stop. Now, of course, that is a matter of speaking, because you know that once you sign a contract, whether you have read it or not, or accepted it or not, it is binding. So once you have accepted and signed a contract, then you know that the clauses within that contract are binding. So both parties will agree to having the clause, the arbitration clause, included within a contract, and of course once it's agreed and signed, then that clause becomes a binding condition of the contract. So they can't then just suddenly choose to go to court and not to arbitration. Okay, don't get yourself concerned about contract law. We are going to look at that in far more details. In fact, a lot of what we're doing now is setting the groundwork for Module 2, because in Module 2 we're going to be looking at the court system in more details. We're going to be looking at the processes for dealing with cases taken to courts, whichever of the courts. So again, you just need to follow the lessons thoroughly, revise, and make sure at the end of each day you've understood everything that we have done. If not, I'm here, you can always ask. Okay, we carry on, a new paragraph. An arbitrator must be a person agreed upon by all parties. Full stop. And this just simply means that, like a tribunal, you may have specific arbitration association which have specific expertise in a particular field, like a tribunal. So once you have a situation where the parties are going to go to arbitration, they simply must agree which arbitrator they're going to have present at their arbitration. Okay, so an arbitrator must be a person agreed upon by all parties, full stop. He or she must not be connected to any of the parties. Full stop. He or she must have relevant expertise and experience in the particular field of dispute. New paragraph. It is usual for a lawyer or ex-judges to act as arbitrator if a particular clause or point of law is being disputed. Full stop. A president, not precedent, a president or head of a professional association may also be asked to act as an arbitrator. New paragraph. An arbitrator must have effective powers to call necessary evidence So to repeat, an arbitrator must have effective powers to call necessary evidence and compel witnesses to attend. Full stop. He could have a subpoena, which is spelled as on the board. He could have a subpoena issued by a court. Now, a subpoena could be a summons. It's another court order, okay? It's just something that you don't ignore. So he could have a subpoena, or it could even be called a court summons. He could have a subpoena issued by the court compelling attendance of witnesses. Full stop. The decision of the arbitrator is known as the award, and if not complied with, can be enforced by a judgment of the Court of Justice. Or Supreme Court, or Court of Queen's Bench, etc., etc. Okay, full stop. The arbitrator can also exercise discretion as to the question of costs. Full stop. When we talk about a question of costs, it just simply means that you can have the expenses of going to arbitration awarded to you, which means that whoever loses will pay your legal costs. Okay. Now, it is also a situation where going to an arbitration does not always involve a solicitor. You can go on your own, but again, people may feel quite daunted, and therefore they will go and seek representation legally. Okay, so we have our arbitration here being yet another alternative to the court system, and parties agree to go to arbitration by including an arbitration clause within their contract. Both parties will agree to the inclusion, and once agreed, the clause becomes a condition of the contract. The arbitration now, the arbitrator must be a person agreed upon by all the parties. The arbitrator must not be connected to any members of the parties, and must also have relevant expertise and experience in the particular field of dispute. It is usual for lawyers or ex-judges to act as arbitrator if there is a dispute relating to a particular clause within a contract or to a particular point of law. A president or a head of a professional organisation may also be asked to act as arbitrator. An arbitrator will have effective powers to call necessary evidence and to force or compel witnesses to attend. He can have a court order issued compelling the attendance of witnesses. The decision of the arbitrator is known as an award, and if it's not complied with, then the order can be enforced by judgment from the superior court. The arbitrator can also exercise a decision or a discretion as to the question of cost. He can also say that no costs have been awarded, so each party pays its own costs. Now, we have arbitration associations basically all over Canada. You have, for example, the Arbitrators Association of British Columbia, and that is located in Vancouver. The members within that particular association have experience in mediation with labour relations, human rights, employment, contract, environmental issues. So it covers a wide range of expertise. So anyone within that locality can always go to the Arbitrators Association of British Columbia. We have another one actually in Toronto, which is the Canadian Arbitration Association, and here they are very good with ADRs. They have alternative dispute resolution professionals, so they can deal with anything in relation to whatever, whether it be points of law, whether it be, I know we have quite often, you have the trades unions going to arbitration because something has come up and they want to go on strike, and before they go on strike they have to try and resolve their issues, and they generally resolve such issues at one of these arbitrations. So the Canadian Arbitration Association would be ideal. Then we have another one actually, which is called the Bayfors International Arbitration, and they're located in Ontario. They have mediation experts dealing with agriculture, business, construction and commercial engineering. So we do have, you just have to look through the directory and find which, or it may already have been contained within a contract that any disputes will go to X arbitration association. So it's already there, you don't even have to go looking. Alright, so we have now concluded the third legal system of arbitration. Again, a break, and I'll see you on the other side in just a moment. Ooh, maybe not a wise term to use. I'll see you in a moment.